Good morning, I'm RASHI GOEL and I am intern at LEXIS and Company. In this video, I'll be discussing about the recent judgment of Satish Ragde versus State of Maharashtra, which is also known as skin to skin judgment. This judgment was recently passed by the Bombay High Court, in which Justice Pushpa Gandelwal held that there must be a skin to skin contact with sexual intent for an act which is to be considered as sexual assault. I was shocked to read the verdict, the way it casually refers to the minor's breast, and the calculus definition of assault is done, where the rates of the commission of offences like sexual assault are increasing in an unfettered manner. It becomes very imperative for the judiciary to step in and stand in support of the victim. But it feels that the verdict does not empower the survivor at all, but rather the abuser. What happened in the case was 12-year-old prosecutrix went to bring guava. As she did not came back for a long time, her mother started searching for her. One of the neighbors told her that the accused took her to his house. After that, her mother immediately went out to accused house and found her daughter crying there. She took her out and rescued her, to which her daughter narrated her the whole incident. She told her that how accused induced her to go with him to his house on the pretext of giving her the guava. She also told her mother that accused pressed her breast and tried to remove her salwar, to which she shouted, and thereafter he went out by closing the door from the outside. After hearing all this, her mother took her to the police station and lodged the FIR against the accused. The main issue here was whether the pressing of the breast of the prosecutrix and attempt to take off her salwar would fall in the definition of sexual assault as defined in section 7 of the POCSO Act. The trial court held that the accused is guilty for the offence of outraging the women's modesty under section 354, kidnapping under section 363, and wrongful confinement under section 354 of IPC, and section 7 and 8 of POCSO Act for touching the breast of the child with a sexual intent, which amounts to sexual assault under the section. The trial court sentences the accused with the imprisonment of 3 years and fine under section 8 of the POCSO Act for the sexual assault and section 354 of IPC for outraging the women's modesty. The case was further reappealed in Bombay High Court, and the court was of the opinion that the accused pressed the victim's breast but without removing the top of the victim, so it would amount to molestation under section 354 of IPC, as there was no physical contact. As the court interpreted the word physical contact given under section 7 of the POCSO Act, which means that physical contact, that is skin to skin, with the sexual intent without penetration. The High Court acquitted the accused for the offence of sexual assault under section 7 and 8 of the POCSO Act and convicted him under section 354 of IPC and sentenced him. What I have analyzed is that Justice Pushpa Gandelwal was very clearly clarified her mind by altering the judgment given by the session court, which held that the accused is guilty of sexual assault under section 7 of the POCSO Act for groping the 12-year-old girl, which she said the meaning of the physical contact under section 7 means direct physical contact, that is skin to skin without sexual intent and without penetration, and accused pressed the breast of the prosecutrix without removing her top and without putting his hand inside the top, as there was no skin to skin contact, so accused is not guilty of the sexual assault under section 7 of the POCSO Act. Also, if we look into the preamble of the POCSO Act, it is also says that the act is meant to protect children from the offence of sexual assault, sexual harassment and pornography, and provides for the establishment of special courts for the trial of such offences. After reading the preamble, it is very much clear that the intent of the legislature while enacting such act was to provide extra protection to the children against the sexual violence. Also, if we read section 7 of the POCSO Act, there is two ingredients which are necessary to satisfy the offense of sexual assault. First, there must be sexual intent, and second, there must be touch to the vagina, penis or anus or the breast of the children. If the above conditions are satisfied, then it is a sexual assault, and also section 7 of POCSO Act is also silent about the direct skin to skin contact. So in the absence of such provision, if any interpretation which questions the protection of the child will be ultra vires, as the main objective of the POCSO Act is to provide additional layer to the protection of the children. So it is very much clear that the judge took a narrow interpretation and unnecessarily created peculiar reasoning which curtails the scope of section 7, keeping in mind the aim of the act which concerns with the protection of children. This judgment will give negative impact to the society and will adversely affect the women's basic right who are the victim of sexual offenses. So this judgment is totally unacceptable and unreasonable and should be negated. Thank you.